Okay. So what I want to do is demonstrate, one, what does it mean to weaken or strengthen an argument in the real world, right? And how you apply that to the LSAT. And then what I want to demonstrate is, if you had the time, I can show you how you would brief. And more specifically, I can show you how you would brief each issue. And if you did that, it would take a while. It would take a while. Might take 6 months. Might take 9 months. Might take 3 months. But it's certainly not going to happen right away. But it would really, you really would understand what this is about. It really, truly is clinical. Honest to God. So if you're going to say to Peter, you hire me and you want me to weaken or strengthen an argument, it's always the same process. One is, I need to be able to separate the argument's conclusion from the argument's evidence. Okay. So remember, if we go back to an argument, is not a complicated thing. You're dealing with these facts from which you've drawn some conclusion, which you now have to defend because you're a lawyer, right? So you don't just get to say, hang out with a bunch of people who agree with you. You're now going to say, here's my conclusion, and you're going to attempt to persuade me of that, and I don't care about your ideology. I could care less about your ideology. I want so much facts. And the way this works is, when you're talking about evidence, remember the conclusion has to reflect the evidence. If the conclusion exceeds the evidence you produced, then it requires an inference. And we had an example of that last week, right? I mean, on the most basic level, if I produce evidence, one, that this rings, and we all hear it rings, so that's, when I say a proven fact, well, in real life, that means what's the standard? Do I have to prove it beyond a reasonable doubt? Do I have to prove it's just more likely than not? So proof itself is fungible. It's what's the standard. But again, if I say, we hear it ring, that's fact, we'll say that's proven. We see Vicky Gormanly's name on it, we'll say that's proven because we see the name, right? We see a phone number, so the phone number itself is proven. And then you have my testimony, and my testimony is that that number is Vicky's number. And we could say, based on testimonial evidence, that was proven. Okay. But now we have my conclusion. My conclusion is I say, hi, Vicky. But we haven't proven it's Vicky. We've proven that this has gone off. It's some kind of notice, we rang. There's a name. There's a phone number. And I recognize both. That's what we've proven. It does not follow from that Vicky's on the other end of the phone. Do we all agree with that?
Yes.
Right. But that's all this is. It's no more fancier than that. And then you would be able to tell me, if you weren't satisfied, you would be able to demand more evidence, wouldn't you? Now, most people would be satisfied with that, depending on, am I saying it must be Vicky? Well, that's not a good conclusion, is it?
Right.
But if I say it's likely Vicky, how about that conclusion? Talk to me, do you see it? So you've really got to pay attention to your words. And what are you trying to persuade, what are you trying to persuade me of? A broad sweeping statement? Or are you trying to persuade me of a probability or a likelihood? That's very different, right? So, the more attenuated that relationship, the more attenuated the relationship between the facts you've established and the conclusion you've drawn, the easier it's going to be to weaken the argument because it's attenuated. Right? The more closely knit it is. Which of the following is most strongly supported by the information above? In that issue, they're saying we're giving you a very strong argument, not a perfect argument, but a very strong argument. Okay, I got it. Where is Aristotle? But it's not a big deal. Will you slow down? Will you become aware of the process? So being a scientist, I guess, I'm not a scientist, so I don't know, but, this is the science of reasoning. It's not all that complicated. So when you think about in your own life, boy, if you do this, you'll get so much better at this test, and you'll get so much better at law. If you think about just the views you have now, right? you've already established some conclusion, right? But if you walk this chain back, what facts do you have that are proven? What have you actually proven? Think about what you say, what you claim is evidence, right? But that you claim it's evidence, well, okay, but evidence can be useless. You know what I'm saying? Evidence can be persuasive, evidence can be problematic, evidence can be refuted by other evidence. So, okay. All evidence means it's relevant. That's all it means, it's relevant. It doesn't mean it's accurate, it means it's relevant. So do you get an argument, the first thing you're looking at is, what relevant matter do I have that I've actually proven? And you get in my example, I would say we have proven that Vicki Gormanly's name appears on this phone. That's what I consider proof. Then there are facts you assert but haven't proved. But these are all now conflated because you're not lawyers. So you're mixing in there the facts that you would like to be facts with facts that have been proven, and those are very different things. So you don't get a fact just because you want a fact, right? So you think about, well, when I construct an argument, is this premise something that I've actually proven or established? And if it's not, if it's just a premise that you've done no research on, I heard, that's my favorite saying, I heard, right? And then you include in your argument something you heard, but have not nailed down. So, you get, as a lawyer, you need to make sure, and this is the stuff you like, generally, right? This is the stuff you like. You haven't proven it, you like it. You just like it. That's your position, you like it, and you're inclined not to challenge it. And a lot of people who agree with you agree with that premise, but you haven't examined the premise. But I'll examine the premise, right? So this is what you want in an argument, a bunch of proven facts. Where a fact is not proven, then you can say it's likely. And that's fine. You can then point out to me that I'm not asserting this as a proven fact. I'm asserting this as a fact that, with respect to its conclusion, is likely correct. And that's the major area. You don't know what you don't know. I mean, if you leave here with one saying, that's the saying. You don't know what you don't know. You don't know. You don't know. But you now want to be lawyers and you want to draw conclusions. So it's not an option not to know. When you don't know, your conclusion has to reflect that. So if you're not certain, the best your conclusion can do is come up with probabilities. You can say something is likely and say, I don't know everything, because you're saying your conclusion is likely. That's fine. But this is, I don't want to hear it, I might disagree with it. This is, anytime you hear you're a denier. Oh, fuck you. I mean, it's like, okay, so I have no view because I disagree with you. That makes me a denier, right? That's not a response. If I disagree with you, you can think I'm a denier. You can, that's fine. But maybe there's facts I have discovered that you yourself have not discovered. So this becomes inquiry, not labels, right? And the inquiry is, when you have done with your facts, do you think there could be something out there that's relevant that you have not uncovered? Is that a reasonable assumption?
Yes.
Is it?
Yes.
Is it a reasonable assumption you have done a lot of work, careful work, but out there somewhere is someone else who's done a lot of work and careful work? And is it possible they have found something you have not found? Is that possible?
Yes.
Then humility. You don't then say that person is, and start calling that person names. You say, well, what do you have that I don't have? And if they come up with nothing, you will embarrass them. Now, could facts that are undiscovered be facts that have minimal relevance to your conclusion. In other words, could they be harmless, or could they hurt you a little bit but not crush your conclusion? Are there facts out there that do make your conclusion somewhat less likely, but don't in any way destroy your conclusion? Is that about right?
Yeah, it can be.
Okay, so then those facts you have not assumed the validity of, right? Because they're just they're a pain in your ass. They're not helpful. So, I'm trying a case, and defense counsel, it's an identification case, and the defense counsel puts on a witness who contradicts my witness, right? My witness is saying, John Doe committed the crime. So I have a witness saying John Doe committed the crime, right? Defense counsel puts on a witness who, on cross-examination, she says, I don't think John Doe, I don't think the guy that John Doe is identifying committed the crime. You say, okay, tell me about it. Right. And during that examination, you establish the person has terrible vision, the lighting conditions are awful, the person is a cousin of the defendant. Would it be fair to say that the testimony is not helpful? Because the testimony from this person, I'm not saying the person's lying, right? But is it fair to say the testimony from the witness is harmful to my case? But it's harmful because the witness is saying that's not the guy who did it. But would it be fair to say that, maybe I didn't know this was coming? Is it fair to say that it's not essential to my case, that I can discredit the witness, that I can make the testimony, the value or the worth of the testimony substantially less than it purported to be? So, yeah, okay. So, a lot of facts out there you don't know. You don't know what you don't know. So I didn't know this witness was coming in, right? But as I'm listening, I'm saying, is there anything in this testimony that I've assumed to be false? Is there anything what's the probative value of this? So here, in an argument, there's what you don't know what you don't know. But sometimes what you don't know is not critical and can be rebutted. You just didn't know. Sometimes what you don't know is harmful, but not essential. But here's the muzzle load, right? When what you don't know, when what you didn't uncover, right, that somebody else uncovered, when what you took for granted, right, you took for granted a fact, and that absolutely obliterates your case. In other words, the other side presents that fact, and if that fact is true, then the conclusion you drew is invalid. That's an assumption. So this category of things you don't know what you don't know, things that are undiscovered, where they are essential, they are assumed. So when this area of, in logical reasoning, this whole bloody section is on this, right? So if you're looking to strengthen an argument, you must look at the role in the argument of each sentence. And this is the thing that would take time. If I ever do get around to writing a book on this, that will be how I write it. Which is say, if you really want to do this correctly, you take an argument and you dissect it. Because the author had to construct it. So when the author constructed it, the author said, yeah, this premise is playing a role in the argument, this premise is playing a role in the argument, this conclusion is the argument's conclusion. You get that whatever you're reading has been built up, and therefore can be taken down. And when you take it down, you become really, really, really aware of what role the argument things play. So when you're weakening or strengthening an argument, now we switch to, so does everybody get what the real world is, as best I understand it? Does it really, doesn't it sound like you could do that? But do you get how your opinions, your views could get in the way? Do you get it? Because it's really critical. Because you just don't want to accept this, or you just don't want to, you don't want to do the legwork here because it's uncomfortable for you. Well, get over it. Do something else for a living. That's fine. All right? But this is just all about facts and the relationship of the facts to whatever conclusion you've drawn. So, if there are only two facts in the argument, now in the LSAT, everything that's a fact is proven. You with me? Everything that's called a fact on the LSAT, every time you read a sentence and you say the role in the argument of that sentence is to serve as a premise or as a fact, then you're saying it is. Right? So if the premise is every planet you've never seen is purple, you don't get to argue with that. It's now every planet you've never seen is purple. That's it, good night, lights out. So the LSAT really simplifies this because that's my world, right? But that's not the world of the LSAT. The world of the LSAT is here and here. Did the facts that were given to you, which are stipulated to be factual, they're stipulated to be factual, right? Do they get you here? Okay. So if you want me to strengthen an argument, right, wouldn't it be helpful if you distinguish the factual statement from an argument's conclusion? Talk to me. Yes. Okay, because once you make that separation, if there are only two facts in your argument that lead you to your conclusion, and one of the answer choices specifically addresses either fact one or fact two, doesn't that kind of seem a direct way to affect the argument's conclusion? As opposed to something that's indirect. Right? So you're thinking about what is the writer doing? And there are three ways to strengthen or weaken an argument. And it's uniform. So the first way is to say, okay, if you ask me to strengthen an argument, and I read fact, conclusion, okay. Would it be fair to say the conclusion hinges on two and only two statements? Okay, well, when an answer choice reinforces statement one, right, makes it stronger, gives it more body, more depth, more texture, didn't you just strengthen the argument's conclusion? Yes. Or if it does the same thing for statement two, don't you give more texture and depth to the argument's conclusion? So you're changing the way you read. You're just changing, say, oh crap, you mean this statement means more than no statement at all? Or, yeah, you bet it does. So when they want to make it difficult, they give you, a bunch of facts, and they they may make it very wordy, and they may make the wording challenging, but nothing changes. It works in reverse if you want to weaken it. The most direct way to weaken an argument is to identify what is given to you as a fact, right? But now you're told to weaken it. So now the answer choices can go at that fact. Then the answer choices can go at that fact, right? And they can say in the answer choices, well, we told you it was fact when you read it, but what if? Do you get that is the way you weaken an argument? You take something that was asserted to be a fact, and that was when you read it, right? But then the answer choice says, well, which of the following, if true? Now, when they say which of the following, aren't they directing you to the answer choices? Talk to me. It's all about language. And it's an artificial test. So now they're saying, well, wait a minute. First they say a fact is a matter for which no support was offered. That's their definition, right? So I read a fact for which no support is, a matter for which no support is offered, and that is now a fact. Okay. But then the question is, which of the following, if true, most undermines the argument? And answer choice B directly addresses this fact. And if answer choice B is true, Doesn't it weaken the argument if the argument rests on that fact? So how do I get you to slow down? Like, we're gonna have this 2-week break, and I mean, we'll be here next week, but then we're gonna have this 2-week break. Man, oh man, if you would just brief, right? And then not worry about when you take the test. I don't care when you take the test. Take it in April, you can take it in June, and for August, you're fine, right? But you might as well prepare yourself for law school while you're here. Okay, so that is one of the dominant ways that you're either going to weaken or strengthen an argument. So do you get what I'm saying? One, you need to pay more attention to the role in the argument of each sentence. Yes, talk to me. You get it. And would it be fair to say that's not something you customarily do in your regular life? So you're changing the way you read. Oh, okay. It's really kind of cool, actually. All right. You're then saying, I also have to understand the role in the argument with respect to where is the argument's conclusion? What is the thing being explained? There's a difference between a matter for which no support is offered. Do you get that? A matter for which no support is offered. That's a fact. So a conclusion cannot have the same definition, right? So doesn't the conclusion have to be a statement for which some support is offered, right? So the conclusion's got to be broader. You say, well, there was no support offered for that first sentence, but the second sentence, you know what? It's actually afforded some support from that first sentence. Well, you know what it is at that point? The argument's conclusion. Do you see it? Yeah, it's just, there's no going back once you start reading this way, because then you're holding the writer responsible for the writer's words. Who controls the words, the writer or the reader? Right. Yeah, right. So you're representing clients now, right? So do you get, I need to hold the writer responsible. The speaker or the listener, who controls the words? The speaker. But then you say you can't ignore the words because they're inconvenient to your personal views. No. You're going to be terrible at this business. Keep that, your views are whatever they are. This is not about that, right? This is about, okay, I got this. So, and I mean, I don't know anything we do more often than weaken and strengthen arguments, and that's what we do. Okay. So the second way, so you get the first way is now I'm aware, I have a plan, right? So now I've actually read the test with, I don't have more time than the person sitting next to me, but I'm going to use my time more prudently than the person sitting next to me, right? So that person's going to run out of their 35 minutes before I'm going to run out of my 35 minutes. Yes? Now that allows me to read this way. And if I practice reading this way in December, wouldn't it be fair to infer you're likely to read more efficiently this way in April? And even more efficiently in June. And again, in my world, I'm sure there's somebody out there that's gone to law school without a scholarship. I don't know who that person is. You with me? Law school is fundamentally different, and it really rests substantially on the LSAT. Not completely, but substantially on the LSAT. So as you do this, I don't know, like if somebody said, and again, money is, it's your life, so, but if somebody said to you, if you worked at this another 3 months, so like say instead of taking it in February, you took it in June, right? And somebody said to you, but there's a probability, not a certainty, right? But there's a probability that if you did that, you would get $30,000 over 3 years. Right? So no, I'm not going to take the test in February. Or maybe I'll take it, but I'm coming back and fully plan to do it in June. And if somebody said to you, if you do that, there is a likelihood that you'll receive $30,000 over 3 years. Might that influence your decision? Well, it depends on each individual, right? Because for some folks, well, it's not about money. That's fine. But would it also train you to be more disciplined? Would it train you to be more thorough? Would it train you to be more, oh God forbid, prepared. And that's why I'm good at this. I think I am, but I'm good at it because I have that preparation sheet. You know, you don't have to be Aristotle. So, the second way, so you can see, Sarah, well, how else can I test whether or not you're going to be able to weaken and strengthen arguments? Well, one is I'm going to require you not argue with the facts, which is why they define fact the way they do, right? You want to argue with the facts? I want to say there's a polluter out there that we should allow to continue to pollute, and you get all upset. That's nice. Get over it, you know, or go protest or something. But if that's given to you as a fact, then it is now a fact. So one thing I'm testing is, are you going to argue with facts? How about this incomplete argument idea? How about this? Do you think that's pretty common? Do you think it's pretty common that when I go to prepare, well, I've tried more than a few cases. Do you think there's ever a case I've tried where there haven't been undiscovered facts? And if you do, I don't. Do you get we're human beings? You with me? So now again, just think about humility. Could you just accept that your best effort is not a perfect effort? It's your best effort, right? And if your best effort isn't adequate, you shouldn't be a lawyer. It can be lots of other things, but it's got to be adequate to be a lawyer. So I want to test whether you can see what's not there. So I've given you, let's say I've given you 3 facts, and typically then, if that's what I'm going to do, right, then the way it's going to look is you're going to see 4 sentences, right? Likely, one of the 4 sentences will be a conclusion. 3 of the 4 will be factual statements. Would you agree with me that it's likely a significant percent of test takers are not even aware of that? You know, it's like, hello, but that's what I'm testing you on. Because if what I'm going to do is I'm going to allow you to strengthen or weaken an argument that's incomplete, don't you get that in the answer choices, there's got to be something that wasn't in the facts that I gave to you. Do you get it? I never gave you this information. It was undiscovered. But if you had had access to it, you would have, if you were the author, you would have woven that fact into your argument because it would have achieved your objective. Do you see it? Why is that? I mean, you just got to give it time. Just treat this the way you would treat a $100 bottle of wine if you drink wine, which is you're not going to drink it right away. You're going to let it sit. You're going to open and you're going to let it breathe. So breathe, will you? This is way more important than a $100 bottle of wine. So if I do this, do you see that the answer choice might come from out of the blue? Because the answer choice would be what? Undiscovered. It would be new information, right? It would be what you missed. Doesn't that sound like real life to you? Mm-hmm. You know, again, I wouldn't do this. I can do whatever I want to do. I don't do anything, actually. If you get this, you're going to be a better lawyer. There's no doubt about it. So, the second way that you're going to weaken or strengthen an argument is you're going to be aware what can the writer do? Just like if you're dealing with flaws, right? You're thinking, well, what tools are at the writer's disposal? You know, and they say, well, if I see correlation causation, that's a tool at the writer's disposal. Necessary sufficient, that's a tool at the writer's disposal. Then you go over it. And then you see the argument, and lo and behold, you know that's what the writer is doing. And you're going to go to law school. So for strengthening and weakening, the writer either has to take an explicit premise and make it more or less compelling. More compelling, strengthens an argument, less compelling weakens an argument. The more central the premise, the more important it is to the answer. But the writer can also say, no, because that's not the entirety of law. Yes?
I have a question. You know how you say, like, screw the opinions, everything's basically stipulated? So when you're strengthening or weakening, is that, like, not applied to those types of questions?
Run the last part of that by me again?
Sorry. So you say that most of these statements are stipulated no matter.
The facts in your, in other words, when you get to a period, everything to the left of that, if it's a fact, is something you cannot argue with. You're stipulating to it, yes.
So that fact, we're just determining if, like, we're strengthening or weakening the whole entire argument? Like, okay, so it's still a fact, it just could be.
It's a
weak
fact.
Or a strong fact?
It's given to you as a fact. The issue, right, when they require you to weaken or strengthen an argument, they do two things. First is they give you a factual framework, so you can't argue with that, right? But when they say weaken an argument, the wording is, not that this is all about words. Then I say to you, which of the following, if true, most undermines the argument? Capiche? So if A, answer choice A, which you now have to assume is true, directly contradicts what you were given as a fact in the argument, haven't you weakened that argument? So that's how, because the test is artificial. But what they're testing is anything but artificial, right? So, but do you see, I could go into court and I could mistake a proven fact for an asserted fact. You get that? I could do that. I'm sure I have done it, right? Well, the thing about my business is there's somebody on the other side that I don't get to call a denier, right? That person comes up and says, well, what if I, defense counsel, prove that that statement is not a fact? Well, then I've got a problem, depending on how important that statement was to my argument. So all the LSAT is doing is, whatever the issue is, so we deal, again, the big issues are assumption, flaw, weaken, strengthen, and conclusion. Those 5 issues come close to 40 of the 50 questions in logic reasoning. And they spill over into written content. Every single one of them, when you read the argument, you're given a fact or you're given a conclusion. There's nothing else. They want to make it fancy, they can give you a subordinate conclusion and then a final conclusion. There is nothing else in an argument. It's just so straightforward. So the argument, when it's presented, it is what it is. You don't get to change it. When the issue says, which of the following, if true, right? So then you say, okay, now I have to assume this is true, and that could change it. And with weakening and strengthening, you're influencing what was given to you. Does that answer your question? So, you're going to get 8 or 10 of these when you both weakening. And again, I don't see any difference between strengthening and weakening other than, am I helping the conclusion or hindering it? But they've either got to come here, which means I want to pay attention to the explicit facts, right? If they're not doing that, they have to come here, meaning it was an undisclosed fact. So sure, you give me a new fact and the fact helps the conclusion, then you've supported the conclusion. Right? The third and last possibility is they go directly to the conclusion, right? So there are 2 ways you're influencing the factual matters. And then if you're not influencing the factual matters to make the conclusion more likely, well, then you're going directly to the conclusion. And you make a conclusion. If I'm going to strengthen an argument, you get that there's a difference between strengthening an argument by focusing on an argument's reasoning than there is by strengthening an argument by focusing on the argument's conclusion. Could one conclusion have competing conclusions? Could my conclusion that this is Vicky and I say, hi, Vicky, is it fair to say that that conclusion has competing conclusions? Right?
Yes.
It could be Mitt Romney. Right? Not likely, but it could be, yes? So a conclusion is, most of the time, is drawn by the inference, which is okay. Again, the inference is a fact, not in that original fabric of the evidence, but flows from the fabric of that evidence. So there are multiple inferences. It's not just this is one inference, there are multiple inferences that can flow from a given set of facts. So if I want to support an argument's conclusion, don't I make the conclusion more likely if I eliminate a competing inference? Like, did I make this, if I say it's Vicky Gormanly, and let's say in the development of the factual pattern, you had knowledge that Colleen and Carolyn Gormanly are my daughters, that they are often with us, would it be fair, if you took that as a fact, would I strengthen the conclusion that it was Vicky Gormanly by giving you a fact that it was neither Colleen nor Carolyn Gormanly, each of whom had general access to the phone? Talk to me. Everybody get that? Because again, I'm using, as the law school will do, I'm using an example to build to a principle, right? So the principle is you make a conclusion more compelling by eliminating a competing valid inference. It works in reverse. If you want to weaken a conclusion, then you introduce a competing valid inference, right? Which makes it, oh, well, maybe it wasn't. If my conclusion was it's Vicky Gormanly, but I would introduce as a fact that on the day I received this call, I was aware that Vicky had misplaced her phone. If I was aware that Vicky had misplaced her phone, right? And I said, hi, Vicky, would it be fair to say I weaken my conclusion that I still think it's Vicky? Would it be fair to say I weaken my conclusion if I establish that Carolyn and Colleen had access to the phone on that day?
Yes.
This is just work. But again, in case I haven't stressed it enough, and I'm sure I can, when you let your personal view divert you from that view of evidence that you need, it's not going to work. So you've got to be, again, as I, having done this for 20 some odd years, it does seem to me that's the issue, that you're just, a lot of people are just too ideological, and that's not what this is. So, do we have three separate ways of strengthening and weakening an argument? Do you guys get it? Because now I want to go over some examples. Talk to me. Yes? And would it make sense now to go over examples?
Yes.
Okay. So let's do that.